Hi everyone, and welcome back to Bowdie Shorts, making law make sense in 15 minutes or less. In this episode, we're looking at a deceptively simple question. Who are the parties to a contract? And at first glance, that sounds obvious. Surely the parties are simply the people who signed the agreement, and usually that is the case, but not always. What if the contract was made for somebody else's benefit? What if an agent negotiated the deal? What if a company entered the contract through one of its directors? Suddenly, things become much less straightforward, and that's exactly what this topic is about. Now, for SQE purposes, almost every problem in this area comes down to two questions. Can this person enforce the contract? And can this person bind somebody else to the contract? In this video, let's see how the law answers those. Now let's start by putting things into some context with our big picture segment. Contract law generally likes certainty, and one of its starting assumptions is only the parties to a contract have rights and obligations under it. That principle is known as privity of contract, and it sits at the heart of this particular video. Now, privity simply means a contract normally affects only the people who made it. If you're not party to the contract, the general rule is that you cannot sue on it and you cannot be sued on it. Sounds simple. Or at least it was until the court started asking an awkward question. Now, imagine two people make a contract that is clearly intended for the benefit of somebody else. Should that third party really have no rights at all? And historically, the answer was yes. No matter how obvious the benefit, no matter how clear the intention, no matter how unfair the outcome, if you weren't a party to the contract, you could not enforce it. Now, why did this cause problems? Well, because real life isn't always that neat and tidy. People regularly make arrangements intended to benefit others. For example, gifts, insurance policies, family arrangements, employment-related benefits. The law eventually recognized that the strict privity rule could produce unfair results, and that led to an important exemption. We're going to start now by looking at the Contracts Rights of Third Parties Act 1999, and this is probably the most important part of this particular video. The Act allows certain third parties to enforce contractual terms even though they did not actually make the contract. In other words, a person can sometimes acquire contractual rights without being a contracting party, and this represents a significant exception to the traditional privity rule. So when can a third party acquire rights? Well, for SQE purposes, there are two main situations. The first is where the contract expressly states that the third party can enforce a term. That's easy. The parties have clearly said what they want, no problems at all. The second situation is where the contract appears intended to benefit the third party. And if the contract is clearly designed to confer a benefit on somebody, that person may acquire enforceable rights. So who must this third party be? Well, the Act does not allow complete strangers to appear out of nowhere and to claim rights. The third party must be identifiable, and that must be by name, as a member of a class, or through a specific description. So a contract might refer to a named individual, employees, family members, even tenants. As long as the person can be identified, the requirement is satisfied. Now, when it comes to the SQE exam, whenever you encounter a third-party rights problem, ask, was the contract intended to benefit this person? If the answer is yes, then the next question becomes, is this person identifiable under the contract? Now, if both elements are present, the Act may allow enforcement. Now let's look at a completely different question. So far, we've been asking who can enforce a contract. Now let's ask who can make a contract, or more precisely, who can make a contract on behalf of somebody else. And that brings us to the concept of agency. Now, an agent is somebody who acts on behalf of another person. The other person is known as the principal. And the principal is the person ultimately affected by the contract. Now, agency is far more common than students often realise. Examples include travel agents, insurance brokers, auctioneers, company directors, even shop assistants. The crucial point is that the agent is acting for somebody else. Now, why does agency matter? Well, because an authorised agent can create contracts that bind the principal. The contract is not between agent and customer. Instead, it is usually between principal and customer. The agent simply acts as the bridge between them. So the key question in SQE terms is, whenever you see an agency problem, ask, did the agent have authority? Because authority determines whether the principal becomes bound. Now, this leads us to a couple of types of authority to consider. So the first one is actual authority. And this means the principal has genuinely authorized the agent to act. Sometimes this authority is express. In other words, you may enter contracts on my behalf. Simple, actual authority established. Then we have implied authority, which, as you can imagine, is authority that arises by implication. For example, a person may be employed in a role which naturally carries certain powers. A sales representative may need authority to negotiate sales. A director may need authority to enter commercial contracts. Those powers may be implied, even though they were never expressly listed. But what happens when the agent exceeds their authority? What if the agent does something they were never actually authorized to do? You might assume the principal escapes liability. The answer is not necessarily, because another form of authority might exist. That's called apparent authority. Now, this is where students often get lost. Let's simplify this. Apparent authority exists when the principal creates the impression that the agent has authority, even though in reality they don't. The focus here is not what the agent said, the focus is on what the principal said or did. Now, why does the law do this? Well, because the law wants to protect innocent third parties. So suppose a principal presents somebody as their representative, a customer reasonably relies upon that representation. The customer enters a contract believing authority exists. The law may prevent the principal from later denying that authority. Now, three things must be shown for this to happen. First, the principal must create the appearance of authority. Second, the third party must rely on that appearance. Third, the third party must change their position, usually by entering the contract. If those elements exist, apparent authority may arise. Now, when apparent authority exists, the principal is bound, even though the agent lacked the actual authority. However, the agent may still be liable to the principal for acting outside of their instructions. Now, students often think agency creates an exception to privity. It doesn't. The agent doesn't acquire contractual rights simply because they negotiated the deal. Instead, the contract is still between the principal and the other contracting party, and the agent simply facilitates that agreement. Once the contract is formed, the agent generally disappears from the picture. So what's Bowdie's bottom line here? Well, every party's question starts with one of two issues. Either, can this person enforce the contract? Or, can this person bind somebody else to the contract? The third party rights ask whether the contract was intended to benefit the person and whether they can be identified. The agency asks whether the agent had authority. Remember, actual authority can be express or implied. Apparent authority arises where the principal creates the appearance of authority. An authorized agent binds the principal, not themselves. And never forget the starting point for the whole topic. Only the parties to a contract normally have rights and obligations under it. Everything else in this video is really an exception to or an application of that principle. Thank you very much for watching this Bowdie Shorts video. Please look out for the other Bowdie Shorts videos available now.